And for those of you that take Uber, and I'm an Uber girl, have for a long time, the multi-billion-dollar global rideshare company Uber's lost a landmark appeal against a New Zealand court, which has ruled that drivers should be treated as employees, not contractors. In 2022, the Employment Court made an historic ruling against Uber when 4 Uber drivers were granted workplace protection. This gave the driver employee benefits such as leave entitlements, minimum wage and holiday pay. Uber appealed against the decision in June last year, but yesterday the court dismissed the appeal, ruling in favour of the drivers. Now, this decision applies to the 4 drivers who took the case against Uber, but this could, of course, set a precedent for other contractors who work in the gig economy. What does it mean for other businesses, for contractors, freelancers? Well, joining me now, good to have him back on the show, employment relations expert. It's Max Whitehead from the Whitehead Group. Max, hello.
Hello, Leah. How are you? Good intro, I'm going to say. I think you explained that pretty well.
Oh, look, I try, Max. I try, you know. I've got you on the show, so I've got to impress. Hey, Maxie, before we get to this particular case, can we just rewind a little bit and can you explain briefly the major differences between an employee and a contractor?
Right, well, going way back in time, an employee was somebody who worked from, like the old song, 9 till 5, but no, usually worked from 8 till 5, and they were, and were dedicated to one employer, and everything was fine. But with there were a few sprinklings out there of individuals who were genuine contractors. Like my dad was a painter. He would go and paint a house under contract. And those people were recognised. A lot of tradies were all doing the same, and they were contractors and completely separate, ran their own business, did their own invoicing, paid their own tax, all those things. Now, since then, of course, the world's changed dramatically, particularly in the last 5 to 10 years, where there is now, like the gig economy, what we've got now is a lot of digitisation. People no longer work in one workplace and work 9 till 5 or 8 till 5. They work from home, or they work in all sorts of locations, or even vary it. And, they call it hybrid. And there's all sorts of different ways of working these days. And the whole nature of work's changing with technology, robotics, and AI, which is, I think we're still on the verge of some huge changes to the way work's actually conducted. But unfortunately, employment law has been quite rigid in its way and stuck to the old traditions. We've had the Holidays Act, a very good example. But certainly with this one, there's been quite a few challenges. I mean, when is a worker a contractor and when they're not? And that's the question you've just asked me. So they developed a set of tests on that, and there was 3 fundamental tests. It was really, the control, the way they were integrated into the organisation, and sort of the fundamentals of, how did they actually do their work and were they actually independent business type people. So those 3 tests were made and life was carrying on. But then the courts buried it. There was a Dyson case, which was about I think it was called 3 foot 4, where Simpson Grierson took it right up to the Supreme Court. And then they started messing with the 3 simple tests and introduced some other variants to that. And they are still law today. Now, of course, Uber comes along, and that's a really weird kettle of fish.
Are they, Max, is Uber is basically, it is a contract, isn't it? It's a you've got flexibility to do what hours that you want. At this stage, that's how it works, isn't it?
Well, you see, Uber say, well, no, we have nothing to do with it other than we facilitate the relationship between the driver and the passenger. We facilitate that, and saying this is not a traditional employment relationship. Those two are independent, and however, we provide the connections for it and the app for it, etc. That sounded very simple and straightforward, and of course that's how the world's bought it. But then the courts have got into it and examined it closely, and they said that you've got quite a stringent contract on the Uber drivers. And they said yes, but that doesn't mean that we're their employer. And it's got words all in there that say that we're not employers. And that's where we've had all sorts of appeals worldwide.
So in this particular case, it only affects supposedly 4 drivers, Max, but you don't believe that, do you?
Not in a glance. This is significant, and so does the judiciary. They realise this is huge because worldwide it's having a huge effect. I mean, Uber is renowned for these decisions, and that look, this decision even says it affects only these 4 people, and each situation is unique. Well, we all know that employers and everyone else fall into a pattern. And if we can get everyone to do the same thing, well, life's more simple and easy for us to understand. And that's traditionally how it happens.
So the conversations that I've had with Uber drivers, and, and I've had a few when I'm in the car, Maxie, how I like a chat. A lot of them that have picked me up, they say that they, we say, well, how long have you been, how long's your shift?
Yeah.
And they've gone, I just came on now, or I'm going to finish maybe after you, but I said, how long have you, today I've only done 8 hours, or today I'm going to do 12, but I won't work tomorrow. They on the ones I've spoken to, liked the flexibility to be able to do the hours that they wanted, minimum or maximum. If by the fact that now they're supposed to be treated like employees, that would mean, would it not, getting holiday pay, sick leave, all the entitlements that come with it, will they now have to do a set amount of hours that is deemed by Uber?
Oh, you do ask the good questions, because that's exactly right. Now, they now have been said by this high-level court, the Court of Appeal. There's only one more above it, and that's the Supreme Court, said that they're employees. Now, while that's happened, that means the employer has to then comply with the law, and that requires them to have an employment agreement. The Employment Relations Act, which is the law, requires that document to have the hours of work specified in it. It requires an employer to give an undertaking in terms of guaranteed hours of work. And with that, all their flexibility, which they have enjoyed, maybe I'll only do 2 hours today, I'll only work tonight, and maybe I'll go and do my other job next week. That's really gone. And they're going to have to be regimented into performing in accordance with the contract. And while they might be making a bit more money because they'll have holiday pay, which is an 8% loading, and then maybe they get sick leave and all the other benefits that come with it, minimum wage, all these guarantees, and they can sue their boss if they growls at them, wrongly, or whatever it might be. It's going to come at a cost to them too. Their flexibilities is not going to be as enjoyed much as they had in the past.
And Max, won't the cost also come to the people using them, because surely the fees are going to have to go up if Uber is going to, having to pay sick leave and holidays and, bereavement leave and I don't know, all these other things that come with being an employee.
Parental leave, there's domestic violence.
Well, exactly. I mean, if you're an employee, that's what you're covered, isn't it? So Uber, and the beauty of Uber, as anyone can tell you that takes them, they are sometimes half the price of a normal taxi. And they won't be able to keep those charges low. So then what's the point of them?